Arvind Narain, I guess we all know him in Bombay, though he's not from Bombay. Pass out of NLS Bangalore, founder member of Alternative Forum, as part of Voices Against 377, has done commendable work in the litigation on 377. And thank you, Arvind, for being here.
It's a pleasure to be here in the PUCL, and as Anand said, it's very important that the PUCL is taking up this particular event. In particular, I'm happy to be sharing the space with both Anand, Chayanika and Vijay, whom I know very well from the past. And that mic? And with respect to, again, we owe a lot to the kind of work which has happened in the number of years Anand has taken on this particular matter. And in a personal sense, I just want to share that in 1997, when we were organizing a gay rights conference in the National Law School as unknown students, we wrote to a range of people to come and speak and to address the issue of sexuality and law. And Anand very happily agreed and came and spoke. And he opened the space out of thinking about law and sexuality. And in a sense, we have a range of activism which happened later throughout the country, and definitely in legal spaces in terms of the founding of the Alternative Law Forum, and the central role that LGBT rights has, we would really attribute to Anand. The other point I want to mention, which Anand briefly mentioned, which I think is very important, is I think his role is as a leader in terms of how do you keep a sense of inspiration going. Very often we have activists, and as activists we all know, we can portray the dark and damp picture of the world as it is. And that is not necessarily the most productive thing, because what you need to do is cultivate politics of hope. And who does that? Nobody does it better than Anand. Give you one example. When the petition was dismissed, the Delhi High Court petition, and I remember the meeting we attended, and everybody was down in the dumps. Anand's point is, this is a big defeat, but we will fight back, and we will go forward from here. And he kept the spirits of the community up, and that's a very important thing. So Anand played the role of both a lawyer in the court and an activist who keeps the community together. And that's a very rare combination. I think we are very happy that he's been so much a part of the struggle for so many years. And with that small note of appreciation, because publicly, as Arvind mentioned, we often end up arguing over a range of matters in good faith. But we never really take the time out to acknowledge what each of us has meant to each other in the course of a struggle. And I think this might be a moment to acknowledge one aspect of what Anand has meant in terms of the LGBT struggle in the widest possible sense. I will pick up from where he left off in some ways and point out to some of the high points and the low points of the struggle. 2009, as Arvind indicated, was really a high point. And why was it a high point in terms of the judgment? It was a high point in terms of the judgment because what the judges did is, for the first time, they applied the notions of privacy and dignity to the lives of LGBT persons. For the first time, they actually said that there's a notion of dignity involved with the question of choices you make about your intimate life. That who you choose to be in love with or who you choose to be with is something which is integrally linked to the notion of dignity. So privacy and the question of making choices about your life is linked to the notion of dignity. That's a contribution the Delhi High Court gave us. Two other contributions they did. Firstly, they put this notion of LGBT rights within the framework of the Constitution. And that again is a big contribution. They referred to the Constituent Assembly debates and the speech by Nehru to make the point that the heart of the Indian Constitution is inclusivity. And if inclusivity is the heart of the Indian Constitution, then we cannot then discriminate against LGBT persons. The second concept they gave us is Justice Shah referred to the notion of constitutional morality, which today is the buzzword in judgment after judgment after judgment. And we'll go back to the fact that when Ambedkar made the speech on constitutional morality in the 1940s, for the 40 years or 50 years after that, no judge thought fit to pick up on the notion of constitutional morality. The first judge to pick up on it was Justice Shah. And why was that important? We'll get to that in a little while. But that was important because it basically laid the foundation for the idea that we must have a way in which we transform Indian society as it exists. The 2 points which Ambedkar made, which are very, very crucial. He made the point that democracy in India is a top dressing on a soil which is essentially undemocratic. He went on to say that constitutional morality is not a natural sentiment. Our people have yet to learn it. We have to cultivate it. So he's basically saying Indian society is hierarchical, graded, and divided, and it's the responsibility of the courts to transform or to help in the transformation of Indian society on the lines of constitutional morality. And if you apply that to the context of LGBT persons, what the courts are saying is that we are a counter-majoritarian institution, that India, a large majority of India might function with notions of religious morality, religious majority opinions, but as far as we are concerned, we will go where the notion of the Constitution says, and our responsibility is to protect the rights of the minority, even against the opinions of the majority. That is the contribution of 2009 and Justice Shah and Justice Bolivar. 2013, as Anand already made the point, and as Vikram said, very powerfully noted, was a bad day for law and love. And it's a bad day for love. We all know why it's a bad day for love, because if you criminalize your right, your choice to be with the person you want to be, it is a bad day for love. It's a bad day for law as well, and it's a bad day for law because at the heart of law, at the heart of the idea of the Constitution, is that you don't give up on the rights of any minority. What the justices did in this case, if you take the point which they put forward, they said that let Parliament decide. And the point which we have to make is that if Parliament decides, Parliament is a majoritarian institution. India is a constitutional democracy, which means we go by the grounds of the Constitution, which means the majority opinion cannot, the minority rights cannot be sacrificed at the altar of majority opinion. So therefore, it's a bad day for law and love, in terms of the way I understand Vikram said's statement of 2013. How did we get to 2018 and this particular judgment which we are today celebrating? One point in between, of course, was the privacy judgment. Again, I want to make a couple of points over the privacy judgment. Why is the notion of privacy important at all? Some people argue that privacy is at best a second order right? I mean, why do we talk about the right of what you want to do in the privacy of your home? Why is that so important at all? It is important because the judges here take forward a more deeper and more expansive notion of what is privacy. Justice, again, Chandrachud, in his opinion, makes the point. He says, what is the heart of privacy? The heart of privacy is the idea that I know that nobody is looking over my shoulder. If I know that nobody is looking over my shoulder, it allows me the space to develop a dissenting imagination, a dissenting worldview, a dissenting way of life. Talk about artists, talk about dissenters, any part of the world, that imagination is nourished by the fact that I can grow regardless of what society thinks. So a dissenting imagination, if you want a plurality of Indian society, want a heterogeneous Indian society, it's very important that we allow our dissenters, our naysayers, those who choose to have a different way of life to flourish and to grow and to develop. And that's the heart of why privacy is so integral to every right under the Indian Constitution, which is why 9 judges of the Indian Supreme Court declared privacy to be a fundamental right. The other point they made again is a very sharp and very powerful critique of the logic of Kaushal. They made the critique of three points again. Firstly, they made the point that when you use the word minuscule minority, the Constitution includes rights for all persons. Therefore, even if you're a minuscule minority, you're entitled to constitutional rights protection. Secondly, they made the point that if Kaushal made the point that so-called rights of LGBT persons, Justice Chandrachud's point, is it's not so-called rights, but real rights dwelling in privacy and equality. And the third point, of course, is when you say let Parliament decide, it's not okay for Parliament to decide because we cannot have the right to dignity and integrity of the individual person subject to the norms, either legislative or popular majorities. Again, a very important notion today, that the rights of a minority cannot be sacrificed at the altar of either legislative or popular majorities. And that lays the groundwork in a sense for the decision which we're celebrating today, which is Narain Singh Johar. And I think on Narain Singh Johar, the only point I really want to begin by making, is to say that we should see that judgment as maybe authored in Delhi, but really authored by a range of ground level struggles really around the country. And I think in a sense, I get that sense very strongly in terms of the activists from Bangalore, where transgender people from the streets will say that, we are very happy with this judgment because we fought for it. And we had a program in Bangalore the other day in which they were looking at the video footage of the last 15 to 20 years. And there were protest after protest in which the range and diversity of the LGBT community was represented. And people will look back on that and said, we feel a sense of ownership of the struggle. It's our struggle, it's our victory. The sense that we were all a part of this entire process, and which resulted in this marvelous judgment. And if we go to the language of the judgment again, I want to make the case that it's an extraordinary judgment. It's an extraordinary judgment because of the tonality in which it is phrased. Every judgment speaks from on high. The judges tell you what they think, and the judges order you around. This judgment begins with a very, very remarkable sentiment. If you read Justice Chandrachud's opinion, he begins by making the point that it is this law has been in place since 1860. The Constitution is in place for the last 70 years, and in the last 70 years we have done nothing about the range of suffering and violence and misery inflicted on LGBT persons. He says we're sorry that we've done nothing. He says we're sorry because we have a range of suffering in terms of Nashirwan, in terms of a range of Khairati, range of people who have suffered under this particular law. And the fact that we turned a blind eye to this, we're sorry. And again, what is an apology? An apology is meaningful in two contexts. An apology is meaningful when you express your own responsibility for inflicting a state of suffering from an entire community. And an apology is meaningful when you say you're going to do something about it. And I think in this case, the judges do both. And perhaps the judge who best articulates this is, again, Justice Indu Malhotra, who Vijay referred to, who starts by making the point that history owes an apology to LGBT persons and their families for the kind of suffering which has been inflicted on the lives of LGBT persons. So the question of the apology, I think, triggers a very different kind of sentiment in a judgment. Again, the comparison, Nalsa is a very important judgment. I should mention that in the trajectory I just outlined. But if you read Nalsa, it's motivated by a sentiment of pity. If you read Navtej Singh Johar, it's not pity, it's a sense of atonement. He's saying we have done wrong and we feel we have to do something about what we have done. And that sentiment, I think, produces this very high order or judgment of a different quality itself. And what is the different quality of this judgment? Again, it borrows from the privacy judgment and articulates the idea that privacy is not just zonal privacy. Privacy is about my right to make decisions about my intimate life, be it the person I want to be with, be it the kind of decisions I make in terms of how I further my own life project, be it a range of things that link to the autonomy of the human being. And how privacy in that sense obviously links to the question of dignity. So privacy and dignity as two interrelated concepts which really cannot separate out at all. That's one concept which Navtej Singh Johar makes very powerful. The second concept they make, I think, which develops in a sense, draws from the notion of privacy and dignity, is the articulation of what Justice, again Chandrachud, calls the right to love. And when he calls the right to love again, there's a certain critique of the right to the love, maybe in PUCL, I don't know in PUCL circles, but maybe in certain progressive circles. Aren't we talking about a certain kind of bourgeois right? What is the right to love in your Archie's cards and why are you going on and on about it? And I think the answer Justice Chandrachud provides is you need to contextualize the right to love in the society we live in. And the society we live in, you get killed for loving across lines of caste, lines of gender, lines of class, or lines of religion. So it's a deeply meaningful right in the society we live in. If you're challenging the structures of caste, or gender, or sexuality, you can get killed for that challenge. And that is the meaningfulness of the right to love. Again, if you go back to the judgment, the reference point is actually Ambedkar and annihilation of caste, where the idea that when blood begins to mix with blood, that's when you begin to transform society, and that's when you begin to face the challenge or the backlash from society, as it were. And just, I think, the last couple of days, I've seen a range of cases of people getting killed or getting assaulted for daring to love, whether it was lines of caste or religion or gender, as the case may be. So that's the other powerful articulation, which, again, the right to love, read about it. They derive it in a sense, the reference point is Justice Leela Seth's letter, which she wrote when the review petition came out. And she makes the point, the thing which makes life meaningful is love, and to criminalize love is profoundly cruel. And so there's a certain understanding of what love could actually mean. And I want to put this as a point to saying that, is this something, again, as a point of a campaign, if you want to take things forward in terms of reaching out to a wider community of people, is the right to love a way in which you can get together a larger political framework, larger group of people, saying this is what we're defending against the current kind of a right-wing tyranny, as it were. from the right to love, I want to go to the other notion which the judgment very eloquently makes, which is the entire question of the notion of equality itself. Again, why is 377 wrong? 377 is wrong because it criminalizes my right to intimate expression, it criminalizes my aspect of my fundamental dignity. But it's also wrong because it sets in place certain kind of prejudice and a stereotype about LGBT persons. Again, going back to Justice Chandrachud, he's the one who makes the opinion most powerfully, where he makes the point again and again that what this law does is sets in place a stereotype of LGBT persons. And that stereotype now is not just in the legal consciousness, it's in the social consciousness, it's in the cultural consciousness, it's in the popular consciousness. And if you go to a healthcare setting, if you go to a passport office, if you go to a range of places, if there are stereotypical ways in which people perceive LGBT persons, that comes from this law. And the reason why the LGBT community is united in the struggle against this law is because of the stereotypes which this law perpetuates and really puts in place. So from the question of stereotypes, we get to the notion of maybe the heart of what the judgment is based on, which is the idea of what they call constitutional morality. Again, I've already referred to this, but I refer to this again. The judges reference the speech by Ambedkar, where he makes the point that democracy in India is a top wrestling on a soil which is essentially undemocratic. And from that, what you derive is the fact that the responsibility is not just on the state, but on civil society to transform Indian society in the lines of constitutional values. And here the other reference point is from constitutional morality, the judges go on to what they call the idea of a transformative constitution. Again, if you look at the range of recent judgments, they all premise around the articulation of the transformative constitution. If you look at the Sabrimala judgment again, the reference point, the central reference point is Article 17. And the point again which is being made in Article 17 is why is Article 17 there in the Indian Constitution? Why do you criminalize the practice of untouchability? You criminalize the practice of untouchability because the mandate of the Constitution is Indian society must transform in certain directions to allow for greater respect for persons on grounds of dignity regardless of the question of caste. If you look at the adultery judgment again, that's the same point. The mandate of the adultery judgment, again, the point I would put it is this. I don't think, I may be wrong, but I don't think everybody is dying to go to Sabrimala. I don't think the adultery provision is being used that much in terms of prosecution. But it's very important. Those judgments are very important. Why are they important? Because they're making the point that Indian society is still blind onto questions of gender, and Indian society must transform. And what the judges are telling us is we have opened out a certain path. And it's up to all the rest of you all to do your work from now on. And here, what is all the rest of you all, and what is the work which needs to be done? First and foremost, the union government. If you read during the proceedings, the opinion of the union government is really matters to the wisdom of the court. If you see what the judges have to say about this, Justice Narain is very scathing. He says the union government saw the writing on the wall, and therefore they make the point that leave matters to the wisdom of the court. Justice Chandrachud makes the point that I think it's a matter of constitutional rights, and surely you can't be making a submission and leave it to the wisdom of the courts. And again, getting back to Justice Narain, his ending point, he says the union government now should popularize this judgment using all the media at their disposal, be it TV, be it internet, be a range of spaces. And they should also conduct training programs for their officials to ensure that they imbibe the values of what the judgment is putting forward. Again, what is the point? The union government has a responsibility going forward, and what has the union government done till now? It's not okay for us to be celebrating the fact that the union government didn't take a position. It is their responsibility to combat the bias and prejudice which the LGBT community is being affected by. And really, this judgment has no meaning unless we're able to take it forward and ensure that we transform societal morality into constitutional morality. That's the responsibility of the union government, and I would say the state government. If you look at what it says about mental health petitioners, again, they're very clear. They're saying that the judgment puts forward a certain viewpoint on why 377 is wrong. Now it's up to mental health practitioners to transform that practice, to bring that practice into conformity with the law and stop treating people for being LGBT. And Finally, I think, while I spoke about the ambition of the judgment, again, if you look at the ambition of the judgment, I think the judgment is not limited. Every judgment often references the petitioner in some detail. If you read this judgment, Navtej Singh Johar is a name. You read the entire judgment, you don't find Navtej Singh Johar in the description of who he is anywhere in the judgment. And why is that so? Because the judgment is phrased, when you say talk about an apology to the LGBT community, it's phrased in the widest possible sense. The imagination of the judgment is in terms of the apology, in terms of the South African apartheid enforcers to the victims of apartheid. It could be in terms of the Canadian government to the First Nations people. It's put at the widest possible level. That's the imagination of the judgment. While it has that broad imagination, there's a certain modesty to it. And the modesty to it really comes from the fact that at the end of the day, the prejudices and the stereotypes which affect LGBT people is something which the judges cannot alter on their own. That is why I think the judgment opens out a space for all of us, saying how do we take forward the ideas of the judgment. The clues are somewhere there in terms of Nariman's judgment, where he talks about the responsibility of the union government. I think the responsibility is as much on civil society and political society, and saying how do we now use the judgment as a base and transform societal morality, or how do we now move India from being a majoritarian democracy to a constitutional democracy. And perhaps the last point I'll end with is that I think what also the judgment does, along with a range of judgments which have come in recent days, is also open out a certain kind of a politics of hope, saying that that in a time of majoritarianism, it is possible to critique and combat and question this kind of majoritarian sentiment. In a time of majoritarianism, it's the constitution which stands within a majoritarian opinion, and the subjugation of minority rights. And I think what the judgment does is takes us back in a sense to the constitution and says that the ideals there are quite powerful. And how do we take forward those ideals in terms of protecting the range of rights, which the privacy judgment in a sense talks about? Your right to eat what you want, your right to dress the way you want to, and your right to be who you are, regardless of what the state thinks, regardless of what the society thinks. And there's one poem which I thought is particularly, which I used to love, which actually I learned from our friend Akhil Katyal. After the 2013 judgment, he narrated this poem by a black American gay poet called Langston Hughes. It goes something like this. He did it in Hindi, which I thought was remarkable in terms of the first No Going Back rally. The poem goes like this. It says, what happens to a dream deferred? Does it dry up like a raisin in the sun? Does it run like stinking meat? Or does it explode? And I think post 2018, we're in a place where we can think of how the dream can explode.
Thank you, Arvind, for the brilliant analysis of the judgment, and thank you for all your work also.